Good morning, everybody, and welcome to today's episode of WorkComp Blitz. I'm Josh Diggs, and today we are joined by Zach Brown, partner at Orion Risk Management. I'm the director of claims at Orion Risk Management, and we're very excited to have David Nusz join us today of the Black and Rose firm. So thank you very much for joining us today. And
glad to be here.
Today's topic is the ABCs of independent contractors, and the idea is to go over all of the legal changes that California employers need to know with the recent passing of AB 5. And so before we dig on in, David, I'd appreciate it. Maybe you can give us a little bit of background about you and the firm.
Sure. So again, David Nusz. I'm a partner with the law firm of Black and Rose. We have offices throughout California. I work primarily out of our Orange County Irvine office, but also do a lot of work in San Diego. My practice covers the entire state, and I manage the employment law department for the firm. The firm's been together for about 15 years now. I've been with the firm for the last 6. We do a lot of work in the workers' compensation arena, and are developing practice in other areas of employment law, which is my focus.
Excellent. Well, thank you very much for joining us today. And well, let's dig on in. There's some huge news that came down the pike recently about the recently passed legislation, AB 5. It was a really big deal, and a lot of people refer to it as the Uber and Lyft legislation. But can you kind of, first of all, just kind of give us a little bit of brief, just summary, if you will, about what AB is, and then we'll dig into what the landscape looked like before the passing of this legislation.
Yeah, absolutely. So AB just stands for Assembly Bill, and 5 is just a designation for which piece of legislation we're talking about. And it was just recently signed into law by our governor after being, it passed without a great deal of opposition through the legislature, our assembly, and it goes into full effect on January 1st. It really is a follow-up to a California Supreme Court decision that came out last year in 2018, the Dynamex case, which established for California a ABC test in evaluating whether or not an individual should be legally construed as an employee or an independent contractor. So when the Supreme Court issued the Dynamex case last year, there was a great deal of angst, for lack of a better term, among the employer community, and really also among a lot of people who were working as independent contractors about what the implications would be. That case ultimately was clarified to apply only to wage orders, because that was the only issue that was involved in the case that the Supreme Court was considering. Our legislature then came in and basically took that test that the California Supreme Court developed and codified it, and is now applying it in a much more broad, sweeping manner to all sorts of categories of liability in terms of employer-employee relationships.
So that kind of leads us into what you mentioned, the fact that it's far-reaching and really a broad application of it. Can you kind of go over what the legal landscape looks like for independent contractors now before this goes into effect? Because the challenge, as we've discussed in the past here, is that there's different organizations and entities applying different sets of rules, and it really can cause some confusion for employers. Would you mind kind of just briefly going over how each of the different entities applies the current interpretation of independent contractor?
Sure. So if you're an employer or anybody that's involved in risk management, human resources, or practicing law in this area, you are already aware that trying to navigate through all the different entities that control how we treat our employees in California can be a very frustrating process. And it's not uncommon to be completely compliant with one entity's requirements, obligations, and interpretations, while at the same time being non-compliant based on an interpretation by a different entity. So before the California Supreme Court decision came out, we had a lot of inconsistent applications of what we would characterize as the Borello test, which was a case that also came out of a California court, which the California Supreme Court had previously suggested was a good way to evaluate whether an employee was an independent contractor or whether an individual was an independent contractor or an employee. And the Borello test was, it was fairly complex, and it allowed for a lot of flexibility in the interpretation. So the basic question was, how much control does the hiring entity have over the individual or the company that's being hired? But there were originally 9 factors that were considered in looking at that. So that could include whether the length of service of how long it was going to take to perform the service, whether the service was paid by the job or by time, who provided the tools, where the work was done, what the intent of the parties were. So there were a lot of factors that were involved. And it really was a case-by-case evaluation. So
probably pretty hard to check all those boxes too, right? I mean, like the last one is whether or not the parties believe they are creating a relationship of employer-employee.
That's exactly right. That's exactly right. So not only did you have sometimes inconsistent determinations between agencies. So if you have a workers' compensation case, the Workers' Compensation Appeals Board, they look at the same individual and say, well, we would apply the Borello test and determine that this person is an independent contractor, so the employer doesn't have responsibility for a work injury because it was an employee. But you take that same exact individual, the same basic facts and relationship, and you would take it to the Department of Fair Employment and Housing, and they would apply it differently. So it was very subjective, a lot of fluidity. So the California Supreme Court, in an effort to make things easier, that really was their intention, at least that was their stated intention. They adopted this ABC test in the Dynamax case, which theoretically makes it at least more consistent in terms of how you evaluate the relationship and make those determinations.
So before we go on, I just have a quick question.
Sure.
So your opinion, is the ABC test a better route to go than the previously used Borello test? It can be a yes or no. And then, because I know we probably talk an hour on why it is or it's not, but in my opinion, I like simple. So even though there's going to be a lot of nuances and questions and maybe more gray area, I think that this is more clear in my mind than having to go through a 10 or 15 to figure out
I think if your priority is simplicity and being able to evaluate your risk and know where you're heading, it absolutely accomplishes that, because the ABC test is, as opposed to the Borello test, where you look at the 9 to 14 factors and you weigh them and make a determination, which can be very inconsistent. The test, which has now been adopted into AB5, you have to meet each of those requirements. So it's not a process of weighing each one and kind of deciding whether or not your situation fits. If you do not meet the obligations of each of the 3 aspects of the test, unless you're specifically exempted from the coverage of AB5, you're covered. So yes, it is more predictable, more consistent,
more black and white.
More black and white. On the other hand, it's going to exclude a lot of current independent contractor situations, relationships. So it's going to frustrate. It just depends really on the priority
so it's probably a better path, but requires more exemptions.
Yes, and for some companies, it's going to require them to completely overhaul the way they're doing business. Uber and Lyft are the obvious examples that everybody's talking about.
Entertainment industry, right? That's an issue we ran into yesterday or last week.
Yeah, so the legislature, typically the legislature creates the law and then the courts try to figure out how to fix it. In this case, it worked a little bit differently because the court actually adopted the ABC test. The legislature came in behind, but they're already getting a lot of pushback from industries that they didn't think about that are going to be affected. They had Uber and Lyft on the radar, and they knew that those people were going to be frustrated. But you know, I just read an article last week that freelance writing for newspapers, and they, you know, so there are a lot of court reporters. You know, as an attorney, we deal with court reporting companies a lot. A lot of those court reporters work for different companies. So it's got to be sorted out, and it's going to be a fluid process. But
Good. Sorry.
Yep. Sorry. So that kind of leads us to you mentioned the Dynamex case there. So and essentially the birth of the ABC test. So I think we kind of touched on that. So why don't we just actually jump into the ABC test? So why don't we go through each of these steps that now each employer is going to have to take into consideration to make that assessment as to whether or not they should or should not be considered independent contractors.
Yeah, absolutely. So I don't know why they call it the ABC test, because none of the vernacular actually starts with ABC, so that's a little confusing to me, but be that as it may. So the first test is the worker has to be free from the control and direction of the hiring entity, not only in the performance of the work under the contract, but also in fact. So this is not new. That's something that's pretty much been a part of the evaluation historically in most of the applications. The B part.
Before we get to B, what does that include? So free from control. They can't tell them when to show up and when they can leave.
Correct.
You have to work at this location. You have to use this equipment. Those type of things, right?
So
that's the real application of it. Is if they're coming into your building and you have the area for them, and you're providing the computer they work on, and you're telling them that they need to be here at 9, leave at 5. They're not an independent contractor.
So yeah, the A part of this test is really it summarizes and captures all the Borello factors.
Yeah.
Right. So you would use the Borello factors to determine whether or not you can get past A. So that, again, that's not new, and all the things that you mentioned would be part of an evaluation of that. So are you really controlling? Are you asking somebody to perform a service for you? Are you interested in the service? Ultimately, no matter how it gets provided and when and where. I mean, we have schedules and things like that, but it doesn't include the type of things that you look to when you're hiring somebody as an employee. They don't have a uniform. You have to be here at a certain time. You have to punch a clock, that kind of thing. So A is not that new, and it's typically if you've got an independent contractor relationship already with people, you've already kind of gotten through that. If you've gone through the Borello, at least if you've looked at the Borello factors and considered those.
Okay. It goes into the direction. The word direction can be a little misconstrued, right? Because I mean, I could say, hey, this is what I'm trying to accomplish, and so I'm directing them to get to this end result.
Right.
But that's not what they're necessarily talking about here.
It really isn't. It'd be more like if you think about a supervisor
right.
relationship.
That's a better way to to frame it.
Right. And again, that's not really new, and that's still pretty. There's a lot of gray in that, and a lot of things that you talk about. The B part is the new part, and this is where it's going to be difficult for a lot of traditional independent contractor relationships to continue because it's going to be difficult to get past this B part, which is the worker performs work that is outside the usual course of the hiring entity's business.
That's huge.
That's huge. So the California Supreme Court gave us great clarity with one example in the Dynamex decision, which was you own a bakery and you hire a plumber to come in and unclog your toilet. That is an independent contractor situation because the plumber is not a baker and the baker is not a plumber. thank you very much, California Supreme Court, for clearing that up for us.
Super great. And we ran into this with us too. For example, we do insurance, right? We're the middleman for insurance companies and employers. And we were interested in hiring somebody to cold call some prospects. Not exactly what we do. I mean, we do insurance, right? We're not a soliciting firm, or, that's not our specialty.
Yeah.
We can say everybody comes to us.
Right.
Now we're going to make them think to go after them. We're going to cold caller, but it just doesn't work.
It's not a plumber.
Right, exactly.
Yeah. Yeah, so this is the one that's really got a lot of employers, the gig economy, Uber, Lyft. They spend a tremendous amount of money lobbying to be excluded from the legislation, and that didn't work for Uber and Lyft, and now they're spending an unprecedented amount of money putting a referendum on the ballot, and for the next in 2020, they're gonna put a lot of money into an effort to get themselves excluded. And in the meantime, they basically have said they'll fight each case individually that's brought, but they don't fit. They can't get through this speed test because the independent contractors that they hire as drivers are driving, and that's what Uber and Lyft, that's their business.
So what they're trying to do, they are not trying to change the law. They're trying to add an amendment to where they are excluded, right? So it's not going to make a difference to the majority of companies out there if Uber and Lyft win or not.
Correct.
It's not going to make any difference to anybody else.
Right. Depending on how they frame the referendum, so it won't look like Uber, Lyft, or it will, depending on how they couch the language that's presented. And there were several business groups that had more luck, and there's over 50 exclusions from or exemptions from coverage under AB5. Some of those exemptions, for example, I have a lot of hairstylists, beauty salon companies, right? So when Dynamex came out, initially we started tweaking the situation with that client, where I turned what they were typically independent contractors historically, but then we had to tweak it a little bit, and then we turned them into tenants, so they were leasing their space as opposed to paying back a percentage of whatever revenue they were bringing in. Now they've been specifically excluded from coverage under AB5, but there's another list of requirements. So they have to book their own appointments, they have to set their own schedule, they have to collect their own money. So there are a few industries that are completely outside of coverage under AB5, which is important to remember doesn't mean that those individuals, doctors, lawyers, accountants, those kind of people, they still can be employees. So we don't jump to the conclusion now that they are inevitably independent contractors just because they're excluded from AB5. You just go back to the standard Borello test that's been in place and apply those factors to see where they're at. But Uber, Lyft are they're kind of the poster child for the companies that want this to happen, and if it doesn't get changed and they are covered, they're going to have to make a decision as to whether they're going to continue operating in California or hire their drivers in California. So it really is big, and the B part is going to be the difficult thing.
Would that be a snowball effect if half their employees were independent contractors, half of them were actual employees?
Yeah. And,
federally, I guess, because
it's
different in different states.
And also sometimes, you've got companies that are not located in California, but they do business in California. Mm-hmm. So trucking companies and things, and Uber, Lyft. So if you come into California, if you're working for Uber or Lyft and you're an independent contractor in Arizona, but then you cross into California, all of a sudden now you're on the clock as an employee. So how this is all going to be interpreted and shake out, we'll have to see. And again, AB5 doesn't go into effect until January 1st, which applies to everything, including workers' comp and payroll taxes and all those kinds of things, harassment, discrimination under the Fair Employment and Housing Act. Dynamex has already gone into effect in terms of application for wage orders. So that's things like overtime, minimum wage, meal breaks, rest breaks, and things like that.
So I think what is definitely to me, obvious about B, that this is effectively closing out those loopholes that may have existed, or sort of the tangential relationships where something could be reviewed or viewed as independent contractor. Would you agree that this B part of the test effectively boils it down to, if you're a painter and you are hiring an independent contractor to do painting, that is no longer an independent contractor relationship. Do you think that this effectively kind of closes those, tangential or potential loopholes there?
Well, it certainly, if you interpret it literally, that the scenario that you just described, because the painter, even if that painter meets the A part and meets the C part because he's got his own business, he's got his own contracting license. But if you hire him to do work for you and you're a painting company, yeah, then you don't meet the B test.
So
But you can still get a plumber.
what if you hire a company and not a person?
Right.
Is that an easy way out of it, that you can just avoid this whole thing? Because I didn't hire an individual, I hired an employee, and that's not payroll, that's a fee that I'm paying. It's a business expense that I'm paying these people.
So good question. There are carve-out exceptions for business-to-business relationships. Okay, so the business-to-business, if you're using a different, if a business is providing staffing to you, for example, temp agencies, for example, then you're still, as long as there's another 12-part test which is separate, and we probably don't have time to. But yeah, that's a different thing. But for the business that's sending the people to you, that's where the question, for them would be. So they may have some liability for those individuals if they're using them as independent contractors.
Protects the end user, but not the middle.
Right. So Yellow Cab probably was super excited about all of this, right? Labor unions were super excited about all this. But a lot of times it's the result is going to end up coming back and it's going to hurt them as well.
Right.
Because a lot of those people, Yellow Cab uses a lot of individuals that aren't employed by Yellow Cab. They just drive different taxis, and they may own their own taxi. So it's going to be interesting to see how this plays out. It's not unusual for California legislature to create law which makes it difficult to do business in California. We all understand and accept that, but this one is a big one for a lot of industries.
Okay. All right. Sorry, I digress. Let's move on to
Yeah, sure. So C is, again, and this is another one which is part of the traditional Borello test. It wasn't a requirement, but it was one of the factors that would be considered in determining whether somebody would be a legitimate independent contractor, and that's whether the worker is customarily engaged in an independently established trade, occupational business of the same nature as the work performed. The important thing to remember about this now, though, is that where it was just part of a larger analysis under Borello, and one of the factors to be considered, it wasn't dispositive, so it wasn't a required part of the Borello test. A, B, and C under AB5 are all required. So if you manage somehow to get through A and B, but the individual doesn't have an independent business and isn't doing it for somebody else on a regular basis, you still have a problem.
So in English, do they have other clients?
Right.
Are they doing it for 10 different people? You're one of those 10 companies that they're doing.
Exactly.
And the challenge there is that's even a little gray, right? Because it doesn't say you could be working on a project for 4 months. You could technically have other clients, but maybe you need to devote a certain amount of time so you don't have any concurrent clients, but you just had 3 other clients in the last month.
So only work on one at a time, or you're just starting out. Hey, you're my first client.
Right.
I plan on doing it for a bunch of people, but business is slow, so you're my only client. So,
but I'm available for other clients to take on other clients too. So I think that could be some gray area.
Well, it could be a gray area, and a lot of employers, a lot of companies, employers implies that, again, even using that vernacular makes it kind of confusing, but a lot of entities that want to hire independent contractors that might have an independent license would historically try to restrict their ability to work for other companies. So in other words, I'm going to allow you to come in as an independent contractor and
We're
perform the
exclusive.
service for me, but I don't want you to go down the street and do the
Just
same
my
service for
competitor.
one of my competitors. Well, this is obviously going to limit that because that goes to the control aspect, and if you know, so yeah, the sort of
So
the
I would agree
shakeout.
with that portion of it, though. Just my opinion. I
Sure.
think that's probably the right way to go.
Well,
if you're
I-
dictating that they can't work for anybody else, then they are
Right.
your employee.
Right.
That's just true.
Yeah.
And you know, and I think that's ultimately kind of what the California Supreme Court was saying. I mean,
That was the
this is intended to sort of respond to what they perceived as, and what the California legislature perceived as, efforts to maybe abuse the system and avoid taxes, avoid providing benefits to individuals that come with employment status. And for a lot of employees, that is something that's important. So you have individuals that do want health coverage, that do want workers' compensation coverage, that do want overtime and those kind of things that come with employee status. On the other hand, you have people that are, you know, in the seat right next to them, working for the same entity, that would much rather have their independence and flexibility and not want to. So you can't, you know, unfortunately, you can't agree to circumvent this. So even if both parties are really desiring to do an independent contractor relationship and agree to that, that doesn't necessarily make it one under the law.
So through the lens of California Supreme Court, they looked at it as, is this person being exploited for those reasons that you just said, right? Avoiding payroll tax, avoiding having to provide benefits or offer benefits and everything else that goes along with an employee, or is this person truly an entrepreneur?
Yeah.
Right? Exploited employee versus entrepreneur.
Yeah.
Which is it? And so that's what this test
Yeah.
ultimately does, is it dictates who's an entrepreneur and who is being exploited by the company, whether they think they are or they are not.
Right. We know what's best
Through our
for
lens,
it. We know what's best. Yeah. And you know, and quite honestly, frankly, you know, the labor unions, there was organized labor was a big advocate for this, because they don't independent contractors don't have the right to collective bargaining, and so they don't join unions,
Right.
and unions are shrinking, and so they're looking for membership.
Yeah.
They push hard for it. But among the workers, if you took 20 Uber drivers and polled them, probably it would be about a 50-50 split in terms of who would prefer this situation and who would not prefer this situation.
Right. So take Uber, for example. If they now have to become employees, does that give Uber additional flexibility to put restrictions on these people?
Absolutely.
Okay, so now you have to be an employee, so you can no longer drive for Lyft
Right.
and Uber,
Right.
right? Either drive for Uber or we
Right.
have to let you go.
Right. Yes, but it also means that they're paying for workers' comp coverage and
Payroll tax,
all those things, which
benefits.
means
Lunch
that they're
break.
probably not going to be able to continue offering, you know, a gig ride service at a discount, and so it's going to look a lot like a cab
That's
fare,
exactly.
which means the whole thing kind of comes
Crashing
crumbling
down.
down.
Right.
That's what they're saying, and the legislature obviously is saying that's not going to happen.
It's
and
probably somewhat
overreacting.
true. I mean, this could truly cripple some businesses.
Yeah. Right.
I mean, bankrupt them.
It could, and it could provide, you know, for employers that have been doing it in a more traditional way with employees and have had to compete with entities, you know, think Yellow Cab versus Uber. So now Yellow Cab has been at a competitive disadvantage because they have to pay all the costs that are associated with employee status, whereas Uber can cut their fare in half or more. So it's going to impact the consumers for sure, right? Particularly in some areas, like you know, any kind of shared ride service gig economy, and it will impact you know, the business. So,
But either way, it benefits California.
uh,
I mean, more taxes, more income tax, more
unless
tax,
unless it discourages businesses from working, you know, coming into California. So if Uber and Lyft decide ultimately that they can't do business in California, under this model, it doesn't really help because they're not now contributing the
Right.
additional money, which, so.
I think it's been clear California is ready to roll that dice, right? I mean, so.
They just did, so we'll see how it works out. And again, a lot of times legislation passes and it quickly gets, it quickly becomes diluted or watered down or changed. So, in the employment arena in California, it's every day there are changes that impact, how we apply the law and interpret the law. So it'll be interesting to see where this one goes.
Yeah.
Ultimately.
Okay, well, let's dive into some exceptions.
Yeah, so you mentioned some of the exceptions. I don't think we need to spend too much time on it. Doctors, lawyers, dentists, architects, accountants, marketers, travel agents, and things of that nature. So
There's a total of 50 though.
There's 50. I didn't list them all. And all I would say about that is that it's important to remember, just because they are on that list doesn't mean that they are an independent contractor. It just means that you don't have to use the ABC test. You go back to the Borello evaluation, which is what we've been doing with those people before.
So one quick question. Is there an actual itemized list that people watching this can go find? Because everything that I've read, and I'm not that smart, so everything that I've read, there are things in there like, and some insurance professionals.
Right.
How gray is that?
Right.
Is there an actual list that the state of California has put out where they can identify, hey, are we on the exempt list or are we not?
Yes, but it's not gonna probably be attractive to or appealing to most of your audience, or even you necessarily. The list would be in the legislation, so it's in AB5.
So they should reach out to an attorney or
reach out
maybe
to
a
an attorney.
CPA.
Yeah, I mean, if you have a particular question about your particular industry,
They can reach out to you.
Reach out to me. But yeah, you right now all we have, because it hasn't really gone into effect, so it hasn't been interpreted by court, hasn't been codified in terms of regulations that are going to be used to enforce it. We just have the actual legislation.
Okay.
But again, just because you're on that list, and again, like beauty salons, they're on the list, but they have their own new category of requirements. Some of them are just completely exempted from the ABC test under the law, and others have qualified exemption.
So we can definitely dig into that a little bit more, and I think you're right. Reaching out to a CPA or an attorney to get that list to see if your specific industry is being impacted would definitely be prudent. But let's dig into the implications, right? Because what does an employer need to consider, right? And they definitely, I'd imagine they want to get started before it goes into effect on January 1st. But what's the first thing, and what are the first couple of steps that an employer who currently has an independent contractor relationship, what are the first few steps that they need to consider to evaluate before making a decision on whether or not they need to make any changes internally?
Right. So to begin with, even though the law AB5 doesn't go into effect until January 1st, it's important to remember that the Dynamax Supreme Court decision from 2018 went into effect immediately, and it also went into effect retroactively. So it's not a good idea to even assume that there aren't any repercussions until January 1st. So if you have concerns about this, the sooner you look at it, the better, and I think that instinct is appropriate. So the first question would be, am I using independent contractors currently? And if you aren't, then who cares? It's not, maybe it will benefit you. Maybe if you're in industry and there are competitors that are using them, then perhaps then maybe there's reason to celebrate this. But if you are using independent contractors in any capacity as a company in California, and by any capacity, I am not going to include the plumber example that's offered by the California Supreme Court. But if you are staffing your business, or you're providing service to clients, or you're using independent contractors in any way, shape, or form, then it's really critical that you look at the ABC test and see, first of all, am I exempted from AB5? So do I fall into one of those categories where I might be exempted? And if you are exempted, then there's a pretty good chance that you've already looked at the relationship under the legal context of the Borello test factors. But if you haven't done that, and this is a new situation for you, you want to look at that and you want to ask yourself, honestly, going through the ABC, can I really satisfy all three of these elements? And if I can't, then you're really at risk now in continuing those relationships as independent contractor designated relationships. You are now exposed to retroactive wage and hour violation claims. So that would include minimum wage, that would include overtime, that would include meal breaks, rest breaks, all those kinds of things.
Which is the biggest exposure here.
And that's how it came up. So that was the situation in Dynamax, right? We had it was a trucking company. So they were using the trucker that they called an independent contractor, and the California Supreme Court said no. So they go back and they have to now pay this person for all those hours to try to capture it, which we probably haven't been recording or keeping track of because we consider them independent contractors. So look at the ABC test and consider whether or not you can reasonably try and maneuver the relationship into that box, which for a lot of companies is going to be difficult. If you determine that you can't, or you have some concerns that you might not be able to, then you're going to have to determine whether or not you want to continue incurring the risk and hoping that nothing will go wrong. And by nothing going wrong, that would include somebody getting injured on the job, because that will hit the radar at the Workers' Compensation Appeals Board, especially if you don't have insurance for workers' comp, which you wouldn't if you're considering it, or at least you wouldn't for this person. Wage and hour violations, harassment violations, all those kinds of liability issues. And now in California, we have this wonderful legal, as far as I know, it's fairly unique in the country. California private attorney general action allows a private attorney with one client, with one single viable violation under any wage and hour issue to become deputized basically by the California Labor Commissioner to then sue the employer on behalf of their client, but also on behalf of the California Labor Commission for all the employees for all the violations in the labor code collectively, which is similar to a class action, except that even if the class action, the employees can opt in or opt out. So if they don't want to participate in it, they don't join the party. That at least gives you some opportunity to exclude some people. Doesn't work like that under private attorney general action. So even if the individuals that you're working with want to be independent contractors, you want them to be, they want to be, there are all sorts of different ways that this can unfortunately find its way into the legal system, where a court would say, well, they're not independent contractors, and even though that was the preference for both parties, they didn't meet the ABC test. Now you've got legal liability, and not just for them, but also for all the other employees that you're using in that same status.
Okay, so that's a good segue. So that's all the bad stuff that happened. So moving forward, if they want to continue to use independent contractors,
right,
then the independent contractor wants to continue that relationship. Is there something that they can do, or a number of things that they can do to get that independent contractor status? If I'm an independent contractor, what can I do to protect myself from getting dragged into this ABC test?
right.
I start my own company, I get other clients, and I chase clientele that doesn't do what I do, right? Those are the three things. That's a transition they're going to have to make with their business. Otherwise, they may get sucked into being an employee with Uber and they can't drive for Lyft.
Yeah.
Like that.
Well, I wish I had a good answer for you, but unfortunately, the desire of the parties is not going to be necessarily relevant, and there's no way around that E test. If it was the old Borello where they said, okay, here are three factors, and we'll look at these things and we'll weigh them, but they don't say that. They say you have to meet A, B, and C. And the B part is if the people that you are using as independent contractors are doing work that's related to your primary business, they can't be independent contractors unless they're excluded from coverage.
So I have one last question, and we can move on. But for any of those bad things to happen, a wage and hour claim or anything, that has to be brought forth by the independent contractor that they were using, right? I mean,
Not
the
necessarily.
IRS, or like the IRS or the California, one of those boards that
Yeah.
you had listed there, are they going to
Yeah.
come after you and say, hey, you owe this person this, without that person actually coming forward
Yeah.
and initiating that
Yes, yes.
issue?
Yeah, it can, there's all sorts of different scenarios where even if that employee is completely satisfied with the situation, for example, you know, if you've got an Uber driver who goes out and runs over a pedestrian, and the pedestrian gets hurt, or they have a passenger in the vehicle and they get hurt, then all of a sudden the insurance company and the lawyers are looking for insurance coverage,
That's the employer.
and they're going to say, okay, where's your insurance coverage? Where's your liability? Where's your workers' comp? Yeah. So unfortunately, you know, you're not safe even if the employee never makes a complaint, because they can be brought into the legal system. You know, a serious accident occurs and you've got Cal OSHA looking into it, whether the employee wants Cal OSHA looking into it or not. And then that becomes a snowball. So really the only safe thing to do to respond to this is either completely avoid using those individuals, or to hire them as employees. And we're probably running low on time, but just one cautionary note about that is that when a lot of times, because of the type of work that these individuals have been doing for these companies, the instinct might be, okay, I'll bring them in as an employee and I'm going to characterize them as exempt, right? Because I'll just change the title, but I'm still not going to have to worry about overtime and deal breaks and rest breaks and all that, which is not a bad thought to look at that possibility. But in order to legitimately qualify for exempt status, there are just a very few limited exempt categories, and they all have their specific requirements as well.
Test to look at.
It's not about, so, you know, the takeaway is it's not about what you call somebody, right? The title is sort of irrelevant. It would be an independent contractor or exempt. You know, I mean, I've got all kinds of situations where clients will go, oh yeah, of course they're exempt. You know, Charlie's exempt. He's been here 20 years. You know, he's got to be exempt. You know, everybody knows Charlie.
Right.
You know, well,
They could get somebody from a staffing company though, right? As an employer, that would be a way to continue to avoid some of that liability or responsibility, is to, hey, I'll just get it from staffing. So if I need a cold caller or whatever, I'll just call a staffing company and they can provide a cold caller. Then the staffing company is responsible for the WorkComp and everything else.
You know, and make sure it's a reputable staffing company, because we see a lot of those relationships, you know, get drug into court too. General special employer, because all of a sudden the staffing company isn't there anymore.
Right.
We didn't have the right insurance. So yeah, I mean, that's, you know, outsourcing work overseas, using temporary, you know, staffing companies and placement services. There's other ways that you can do this. But if you have been using, if you're doing 1099s and you've been doing a lot of independent contractor relationships, you really need to look at that and make sure, if you decide that you don't want to change it, you at least need to be aware of the risk and make sure you understand it.
Well, I think that a lot of this conversation and a lot of the things that we bring up are all huge company issues, right? They're the Ubers, they're the Lyfts, they're the Pepsis and the Cokes. But the ABC construction on the corner, or the manufacturing facility in Bakersfield that, hey, we just don't have enough people, so hey, call John because he does a lot of this work, right? And we can have him help with this project, but we're not going to bring him on full time.
Right.
So that's the real situations that people are probably running into.
Right.
That, hey, we just need them temporarily. We're not an employee of ours, right? We just need his help on this project, and we're going to pay him a fee to do that, right? So that's the what happens in the real world. Not everybody is an Uber and Lyft situation where 100% of our staff is independent contractors,
Yeah.
and this is going to really dictate if we're
Yeah.
bankrupt or not.
Yeah, there are certain industries, and it doesn't necessarily depend on size, but there are particular industries, entertainment industry, construction industry, transportation industry. You know, so some of those employees are really small, but they just happen to use a lot of this type of service because of the type of work they do. Arguably, sometimes those small companies can not afford to sustain the kind of legal liability that might arise out of a misclassification.
I see that being the biggest impact,
Yeah,
honestly. I mean, other than the one exception, right, Uber and Lyft, that industry, I mean, I was reading through a lot of this ABC test, and I saw a lot of comments from people that this will bankrupt me if I now have to pay all of these things that go along with hiring an employee. The only way this business worked was that I got to not exploit, but utilize this type of worker. So, and that's the sad part. That Uber and Lyft, they can take care of themselves. I don't have too much empathy for those type companies, but the ABC construction on the corner that is forced to utilize that because California is so hard to operate a business already.
I know.
Right? And this is the only way that they were able to still make payroll.
I know. Well, yeah, I mean, all I can say is there is some benefit in not only this area, but every, you know, a little preventive medicine sometimes can avoid a disease, and there are certain things that you can put in place, you know, arbitration agreements and things that can insulate you to a certain extent from a lot of the liability that comes with the employment relationship. But this is going to be tough, and it'll be interesting to see how it plays out and how it's interpreted. That B part is making everybody crazy. The A and the C are kind of part of the Borello tradition. Making them mandatory is going to make it harder. But that B one, unless you're looking for a plumber, the legislature and the California Supreme Court haven't given us a lot of wiggle room yet. At least nothing that's obvious. So we'll see how it goes.
What's your guess when things get litigated? It's like, take my example that we do insurance.
Right.
We're not a call center.
Right.
But we are going to hire a cold caller to make 100 phone calls a day for us.
Right.
And they can do it from home. They can do it whenever they want.
Yeah.
I just need 100 a day. And
but they're calling potential insurance clients and trying to
well, really just setting up meetings for us to discuss insurance.
Yes.
If we took that to court, that's a L.
I'd certainly make the argument for you. I'm happy to do that, but yeah, I mean it's a frustration.
I just didn't know how much wiggle room you actually have in that argument.
We'll see.
That's not what we do.
Yeah,
that's not what we do.
Yeah.
We review policies.
Yeah.
We connect people to insurance.
It really goes down to what's the business. So what is not necessarily what you do within the operation as much as what is the business of the operation. So if the business operation, if you're involved in insurance and they're selling insurance or working to help facilitate your connections in insurance.
Okay, so that would be their argument. If we're sitting there in front of the judge, that would be their argument.
Yeah. So I think their intention is to put, pretty tight limitations on that. And the way they've expressed it, again, the example that they use, makes it painfully obvious that they're talking about completely like, okay, you can still do something with an independent contractor if what you're asking them to do is completely unrelated to what you do as a business. Can a plumber make a cake? Can a baker clean the pipes?
Yep. So let's, just within the work comp industry.
Yeah.
You made a mention of it before. Interpreters, contract attorneys, court reporters. Has there been any fallout, any change? What are you hearing as far as how this can impact them?
Yeah.
With this legislation.
Yeah. So interpreters is they're one of the sort of, I think, one of the small groups of professionals that the legislature has acknowledged they probably need to look at and consider exempting, but haven't yet. And court reporters, I haven't heard anything specifically about, you know, whether or not any of the court reporting companies have changed their model. I think they use a lot of court reporters, not necessarily as independent contractors, but more just part-time. So a lot of the reporters are really just affiliated with one agency and don't necessarily work for a lot of different agencies, but they work when they want to. They can take an assignment or not take an assignment. That's a different thing. You know, they still have to get paid at least minimum wage and those kind of things. But yeah, there's going to be a lot of industries that the assembly didn't think about, and they didn't have enough of the money to go and, you know, get the lobbyists lined up behind an effort to get them exempted, that are just going to have to be addressed. So I do see that happening, and I see it happening with a lot of companies, a lot of particular service providers. We'll have to see.
Well, what's the, I'm about to wrap up here, but what's the one piece of advice that you have for people watching this?
Yeah.
What should they do?
Yeah.
Or if they have questions, or what's step one of kind of correcting?
I would say if they're watching this, I would assume that they're probably, you know, an employer or an entity that's using employees and or independent contractors. Again, if you don't use independent contractors, nothing to really be concerned about. If you are and you have questions, get in touch with me or somebody that practices employment law and is familiar with this, to just see what your situation is and how it might be able to, you know, how you might be able to adjust it. But the sooner the better. I mean, yeah.
What's the best way to get a hold of you?
So Black and Rose is the firm that I work for. I'm in Irvine. My email address, my cell phone is always available, 714-313-3337. Office number 949-435-4260. Yeah.
And we can send out your contact information
Yeah,
as well.
absolutely.
We'll put it in the or in the narrative section of whenever we post this out.
Okay.
Put it out live. So.
Yeah, I want to thank everybody for joining us today. Again, we would encourage you to reach out to us if you'd like a copy of the presentation. We recorded it as well. And feel free to check our websites, social media, LinkedIn, Facebook, Instagram. And any questions, concerns, feel free to reach out. We've also got a bonus webinar on Thursday. That's the Thursday the 14th of this month. Weed at work, and so that's a big topic going along with a lot of employers. So feel free to tune in. You can register, and we'll send a link separately as well. But thanks again for joining our WorkComp Blitz presentation. Thanks, David. Appreciate it.
No, enjoyed it.
Appreciate it.